Hello, welcome back. GovDoc Breakdown, no opinions, just facts and summaries of government documents, and we let you do the rest. June 18th, Supreme Court opinion, NRC, Nuclear Regulatory Commission v. Texas. All right, kind of a weird one today. We are talking about the state of Texas and Fasken Land and Minerals, a private company, and the Supreme Court ruling whether they could challenge a decision by the Nuclear Regulatory Commission to grant license to Interim Storage Partners, ISP, for a private facility in West Texas to store spent nuclear fuel. All right. So the Atomic Energy Act of 1954 requires a license for private possession of spent nuclear fuel, which Interim Storage Partners applied for and was granted by the Nuclear Regulatory Commission. Texas and Fasken believed they had the right to challenge this decision by the Nuclear Regulatory Commission, and so they brought suit against the NRC to the circuit court because federal agency, remember, federal agency, you go straight to the circuit court. No district court. District, circuit, supreme. No district when you're dealing with federal agencies. All right, the circuit court agreed with Texas and Fasken and canceled the license obtained by Interim Storage Partners. However, the Supreme Court just ruled that the challenge to the Nuclear Regulatory Commission's decision was unconstitutional. They did not even rule on whether the NRC's decision was constitutional. The Supreme Court said that under the Hobbs Act, you need to be a quote, party aggrieved by the licensing decision to seek review in federal appeals court. To be a party aggrieved, one must either be the licensed applicant, ISP in this circumstance, or have successfully intervened in the NRC's licensing proceeding. So simply submitting comments or attempting to intervene does not count. You have to have had, at some point during the licensing process, intervened and caused some sort of commotion, apparently. So, in this case, Texas did not actually intervene. They merely provided comments on potential impacts of the license. Fasken actually went a little further and did attempt to intervene, but the NRC denied their attempts. Fasken, appealed the NRC's denial to the DC Circuit, but lost, and then chose not to appeal further. So, since Texas or Fasken did not actually successfully intervene and were not the original applicant of the license, there is no legal authority for them to bring this challenge at all. Therefore, the Supreme Court has ruled that the license is granted and the facility will go forward unless someone with the proper standing in the licensing process can bring suit.
Full video located on our channel.